I never thought replacing a few rotting boards and adding a coat of fresh paint would lead to war with the HOA. It started out as just a weekend project. My old shed in the backyard was leaning, half the roof had collapsed, and the door was swollen shut from years of water damage. It was more of a safety hazard than a structure. My wife had been asking me for months to deal with it, and honestly, I was tired of looking at the eyesore every time I mowed the lawn. So, one Saturday morning, I got up early, grabbed my tools, and decided to finally fix it. Nothing major, just some structural reinforcements, new siding, and a shingled roof. I didn't tear it down or build anything new. The footprint stayed the same. No plumbing, no electrical. Just a solid rebuild of what was already there. 2 days later, as I was admiring my handiwork with a cold drink in hand, a white envelope appeared tucked under my front doormat. No stamp, no name, just an HOA logo on the corner and the word notice in all caps. My stomach dropped before I even opened it. Inside was a formal warning stating that I had committed an unauthorized construction project and that I was in violation of Community Code 14B. I was instructed to cease all work immediately and report to the HOA board within 7 days. What work? It was already done. And what exactly was unauthorized about replacing a broken-down shed? At first, I thought it had to be a mistake, some form letter sent to the wrong house. So I laughed it off, tossed it on the kitchen counter, and forgot about it. That was my first mistake. Exactly 3 days later, another letter came. This one was even more aggressive. It said I had ignored a direct warning, and I was now being fined $100 per day until the structure was removed or approved. What? Removed? I wasn't about to tear down something I just spent 2 full days fixing with my own hands. I called the number listed at the bottom, hoping to explain and clear it up, but no one answered. I left a voicemail, then another, then an email. Still nothing. On the 5th day, a knock came at the door. It was Mr. Campbell as president, clipboard in hand, dark sunglasses like he was some kind of secret agent. He didn't even say hello, just walked around the side of my house and stared at the shed. This structure was not approved by the board, he said coldly. I followed him. It's not a new structure, I replied. It's the same shed that's been there for 10 years. I just repaired it. Campbell flipped a page on his clipboard. According to community guidelines, any structural modification, including repairs, require prior written authorization from the board. You're kidding, right? I said, thinking maybe this was a prank. It was falling apart. I didn't even change the shape. I used the same foundation. He didn't respond. Just scribbled something and handed me another notice. This one with an updated fine total, $500 and counting. That's when I realized this wasn't a misunderstanding. It was a shakedown. The next few days were surreal. I received more letters, more fines, and one even threatened a property lien if I didn't comply. My neighbors began to whisper. One even told me they'd received a similar warning years ago for repainting their deck. Apparently, Campbell and his board had a reputation for strict enforcement, but this was a new level of absurdity. Still, I wanted to play fair. I compiled every receipt, every photo I took during the repair process, and submitted it formally to the HOA's architectural committee, as per their own rules. A week later, I received a one-line email response. Denied. Remove structure or face legal escalation. By now, the fines had surpassed $100. My blood boiled. I wasn't going to be bullied for fixing a shed. So I started digging into the HOA's bylaws, every dry, tedious page. And that's when I found something interesting. An exception clause, according to Article 7, Section D, Any repairs done to restore a previously existing structure to its original form using the same materials and dimensions were exempt from pre-approval as long as no expansion or modification was made. That's exactly what I did. I printed it out, highlighted it, and scheduled a meeting with the HOA board. But surprise, when I showed up, they told me the meeting was closed to non-board members due to pending litigation risk. I wasn't even allowed to speak. That's when I realized something bigger was going on. Campbell didn't just want the shed gone, he wanted control. He wanted people to fear the board. And he wanted an easy win to show the neighborhood who was boss. Well, I had something else in mind. Instead of backing down, I went to the local county courthouse and filed a petition for declaratory judgment, essentially asking a judge to rule on whether my shed repairs were legal under both HOA guidelines and state property law. I gathered photos, emails, letters, and even got my neighbor and architect to write a short letter stating that the fading said saving at my neighbor, an architect to write a short letter stating that the Pain shed's footprint and form had not changed at all. The court date was set for 2 weeks later. In the meantime, the HOA kept piling on the fines. $100 per day became $200, then $250. I ignored them all. Let them bury themselves in paper. I knew I was about to flip the whole game on its head. By the time my court date rolled around, I had a 3-ring binder full of evidence and a fire burning in my chest. The more I reviewed the HOA's actions, the more it became clear. This wasn't about a shed. It was about power. And Mr. Campbell, the HOA president, was addicted to it. A week before the hearing, I received a letter from the HOA's attorney. Not Campbell himself anymore, an actual lawyer. It was a formal cease and desist order with phrases like known compliance, violations, subject to lien, and unauthorized structure will result in further legal recourse. They were trying to scare me into backing down before the judge even saw the case. Too bad they underestimated how stubborn I could be. Showed the letter to my own legal counsel, a friend of mine who's a civil attorney. He read it, raised an eyebrow, and said, "They're bluffing. They don't have a legal leg to stand on unless you expanded the shed, added utilities, or built it on protected land. Did you?" "Not a single change," I replied. He nodded. "Then let them embarrass themselves in court." In the days leading up to the hearing, I started to realize just how much of a pattern this was. Word got around the neighborhood about my court date, and I had more than a few residents knocking on my door with stories of their own. One man told me Campbell fined him $300 for installing a window AC unit without permission. Another woman said they made her repaint her mailbox because the color was too vibrant. Someone else got fined for installing solar lights along their walkway solar lights. No wiring, no digging, nothing that could be remotely considered a modification. Everyone had the same look in their eyes, tired, frustrated, but too scared to fight back. That's when I knew this court case wasn't just for me. It was for every homeowner who had been pushed around by Campbell's little regime. The courtroom. The courtroom wasn't fancy, just a small hearing room at the county courthouse. Simple chairs, a judge's bench, a few pew-style rows of seating. I showed up with my binder, my documents, and a few neighbors in quiet support. Across the room sat Campbell and his lawyer. Campbell wouldn't even look at me, just fiddled with his watch and whispered to his attorney like they were planning how to crush me. The judge entered, a stern-looking woman with sharp eyes and a calm voice. She opened the session and immediately asked for both parties to summarize their claims. Campbell's lawyer went first. He stood, adjusted his tie, and said, "Your Honor, our client, the Hillside Oaks HOA, seeks enforcement of their community guidelines, Mr. Mason undertook unauthorized construction in direct violation of Article 14B, which requires written approval for any structural alterations, repairs, or additions on private property. He handed the judge a stack of documents. I kept my face neutral. The judge flipped through a few pages, nodded, and looked at me. "Mr. Mason, your response?" I stood, calm, collected at least on the outside. Inside, my heart was pounding. "Your Honor," I said, "what I did was not construction. I repaired an existing structure, the same shed that's been on my property since the home was purchased. I did not expand, modify, or add anything new." And according to Article 7, Section D of the HOA bylaws, I slid a highlighted printout. Toward her, restorations of existing structures, so long as the footprint, materials, and function remain unchanged, are exempt from prior approval. The judge examined the section. Her expression didn't change, but I noticed her raise one eyebrow slightly. I continued. "I also have dated photos of the shed before, during, and after the repair, along with receipts proving I used the same materials. Furthermore, I have letters from 2 neighbors and a licensed architect confirming that no change in design or function occurred." I handed those over. For a moment, the courtroom was silent. Campbell shifted uncomfortably. His lawyer leaned in and whispered something to him. Campbell shook his head, frustrated. The judge looked over everything for a moment longer, then addressed both of us. "I've reviewed the documents. Mr. Mason's repairs appear to fall under the exemption clause. Unless the HOA can prove that the structure was expanded or otherwise materially altered, I see no violation." Campbell's lawyer tried to recover. "Your Honor, we believe the siding used." The judge cut him off. "Is the siding the same as the original?" I spoke up. "It's the same type and color." "Just new." She turned back to the lawyer. "Then I don't see a violation. If the HOA wishes to pursue this matter further, it will need to provide concrete evidence of structural modification. Otherwise, I advise you to withdraw your enforcement attempts." Campbell looked like he swallowed a lemon. He stood up abruptly. "This is ridiculous. We run a clean, uniform neighborhood. If people just do whatever they want." The judge raised a hand. "Mr. Campbell, you are not an attorney. Sit down." I won't lie, it felt good to watch him deflate. The judge turned back to me. "Mr. Mason, the court finds no violation of the HOA guidelines. You are not required to remove or modify the structure. Additionally, the court recommends the HOA cease fine accumulation effective immediately." Boom, just like that, back home, I walked out of the courthouse with a copy of the ruling in hand. My neighbors clapped me on the back, smiling, shaking their heads in disbelief. One of them said, "You actually did it. You beat them." Back at home, I taped the ruling to my front door right next to the last HOA fine notice. Let them see. Let them try and push me again. The best part? That wasn't even the final blow. Not yet. You'd think after a judge ruled in my favor, the HOA would back off, admit defeat, maybe even apologize for the stress and hassle. But no, that would have been too easy, too rational. Instead, they doubled down. 2 days after the court ruling, I received yet another notice. This time, it was branded Final Warning. It claimed I was still in violation of community harmony policies, and that the HOA had the right to pursue civil damages for unapproved construction causing neighborhood disruption. Neighborhood disruption? It felt like a joke, but the tone was deadly serious. And what's worse, the fine clock hadn't stopped. They were still adding up daily penalties even though the judge had said those fines were invalid. That's when I knew this wasn't about policy anymore. This was personal. Campbell was offended. His ego was bruised, and now he wanted revenge. Fine. He wanted war? I'd bring the big guns. Remember my civil attorney friend, the one who'd advised me during the earlier court case? I called him back. This time, I wasn't asking for favors. Mark. I said, I need to go on a fence. Not just a fence, he laughed. I was hoping you'd say that. Mark had been working in real estate and HOA law for over a decade. He'd seen HOAs act like this before, treating the community like their personal kingdom, twisting rules, intimidating residents, issuing illegal fines, even trying to claim ownership over parts of private property. He was ready to go to bat for me, and more importantly, he was ready to hold the HOA accountable under state law. We started by compiling every piece of correspondence I'd received from the HOA: the notices, the fines, the threats, and the court ruling. Then we cross-referenced them with the HOA's own bylaws and state statutes regarding homeowner rights and HOA conduct. What we found? A gold mine. For starters, state law prohibits fines from being issued after a matter has been adjudicated in court. Campbell had ignored that. That alone could invalidate the entire running fine total. Second, the community harmony clause they were leaning on was vague and non-enforceable without specific evidence. In other words, unless I was blaring death metal from my shed at 3 a.m., they had no case. Third, and this was the big one, we discovered that the HOA had failed to file the updated bylaw amendments with the county. That meant any rule changes made in the last 3 years weren't legally enforceable, including Article 1(4)(b), the very rule they were using to accuse me of unauthorized construction. When I saw that, I couldn't help but smile. They weren't just being bullies, they were being sloppy. Mark drafted a cease and desist letter that was a work of legal art. It was calm, professional, but absolutely devastating. It stated that the continued fines were in direct violation of a judicial ruling, that further harassment would be considered grounds for a civil suit, and that the HOA board and Mr. Campbell personally could be held liable for intentional infliction of emotional distress and abuse of power under the state's HOA accountability statute. And the cherry on top? Mark included a formal request for a full audit of the HOA's financial records, as permitted by law for any dues-paying member. That part wasn't just about the shed, it was a warning shot. If Campbell wanted to keep playing hardball, we'd shine a flashlight into every corner of his little kingdom. The letter was sent certified, mailed to the HOA's legal representative, and hand-delivered to Campbell's home. I would have paid good money to see his face when he opened it. For a few days, it was radio silence. No notices. No emails. No smug walks by Campbell. Just quiet. Then I got an email not from Campbell, but from the HOA's lawyer. It was short, formal, and careful with its language. Dear Mr. Mason, we have reviewed the court's decision and your recent correspondence. Please be advised that the HOA will be rescinding the fines issued as of date and will not pursue further enforcement. Action regarding the shed structure. We apologize for any inconvenience this has caused. Sincerely, HOA Legal Counsel. Translation. We screwed up, we know it, and we're backing off before you destroy us, but that wasn't enough for me. Not after the stress, the time, the legal fees, the anxiety my wife had gone through, and the neighbors who were still too afraid to speak up. This wasn't just about me anymore. It was about standing up to the power-hungry gatekeepers of our own neighborhood. So I pushed forward. Mark, and I filed a formal complaint with the State Department of Housing and the County HOA Oversight Committee, citing abuse of power, improper fines, and failure to file amendments. We attached all the evidence, including the rescinded fine notice. It wasn't just a legal play, it was public. Once filed, these complaints became part of the HOA's official record, available to any future homeowner or auditor. Word spread fast. One by one, Neighbors began showing up at my door or messaging me online. Some had stories, some had questions. But all of them had one thing in common: they were tired of Campbell's nonsense. One elderly couple had been fined for installing a wheelchair ramp. Another was told her American flag violated aesthetic guidelines. A single mom had been sent threats for putting up a swing set in her backyard. I shared my story. I shared the documents. I told them they didn't have to be afraid anymore. That's when something beautiful started to happen, a movement. A few of us decided to form a committee to challenge Campbell in the next HOA election. We reviewed bylaws, talked to local officials, even hired a community mediator. And the more we dug, the more people realized how far Campbell had strayed from what an HOA was supposed to be by now. I had gone from homeowner to local hero. The shed was still standing, stronger than ever. And the court order was now framed in my office. Campbell had gone quiet, but I knew he was watching, waiting, hoping I'd stop, but I wasn't finished yet, because while the shed was the battle, transparency was the war. And what I had planned next was going to expose everything. The court victory had been satisfying, but not enough. The HOA rescinding my fines and sending me a weak apology felt like a Band-Aid on a broken dam. Because the real issue wasn't the shed. The real issue was a corrupt HOA president using fear, fines, and fake rules to control an entire neighborhood. And it wasn't just me anymore. The more neighbors spoke up, the more clear it became Campbell had turned our HOA into his personal dictatorship. Arbitrary fines, secret votes, unannounced rule changes, and zero transparency with the community's finances. That last part? That's where things got serious, because once we sent the audit request, everything began to unravel. By law, any HOA member in our state can request to see the financial records of the association. Budgets, expenditures, contractor payments, all of it. So when our legal team made the official request, we expected the board to comply. But 2 weeks passed, and we got nothing. Not even a reply. So we sent another request, this time via certified mail. That's when we got a short letter back from Campbell himself. It claimed that the records were currently under review and not available for public release due to internal auditing procedures. That was a red flag the size of my backyard shed. Mark, my lawyer, was already 2 steps ahead. He filed a petition for discovery with the local civil court, citing a refusal to release financial documents as a violation of state transparency laws. When the petition was approved, the court issued a subpoena for the HOA as full financial records. Now, Campbell had no choice. They had to hand over everything. And when they did, what we found was shocking. Within 2 days of receiving the financial documents, Mark had flagged over $15,000 in unexplained expenses. There were monthly consulting fees to a company no one had ever heard of, later revealed to be registered under Campbell's cousin's name. There were lawn service payments far above the local average, and vague line items labeled community upgrades that had no physical evidence. But the biggest kicker? A $4,200 payment listed as emergency roof repair, HOA office. We don't have an HOA office. That's when it hit us. Campbell had been diverting HOA funds for personal use, possibly even for repairs or upgrades on his own home. It was fraud. And now, we had proof. We filed a formal lawsuit in civil court. Mason v. Hillside Oaks HOA and President Campbell, citing abuse of power, embezzlement of HOA funds, unlawful fines, and violation of homeowner rights. Mark attached everything: the original court ruling about my shed, the subpoenaed documents, and sworn statements from 4 other homeowners who'd experienced similar harassment. But we weren't just asking for damages. We were asking for Campbell's permanent removal from the HOA board and a court-appointed financial monitor to oversee the HOA's spending for the next 2 years. The court date was set for 3 weeks later, and the neighborhood buzzed like a beehive. People who'd been too afraid to speak before suddenly had stories, documents, even photos. We organized a community meeting, and over 40 households showed up, nearly half the neighborhood. And they all had the same message: we're tired of being scared. It's time for change. The courtroom was packed the day of the hearing. The local news even sent a reporter when they heard the HOA president was being accused of misusing community funds. Campbell walked in red-faced, trying to look confident, but you could see the sweat on his collar. His lawyer tried the usual tactics: deflect, deny, downplay. He claimed the financial records were misinterpreted, that the community upgrades had simply been delayed, and that Campbell had every right to enforce the HOA's policies as written. But then Mark took the floor. He didn't just argue, he presented. Slide by slide, receipt by receipt, photo by photo. He pointed out the fake office expense, the cousin-run consulting firm, and the inflated service charges. He reminded the judge that not only had Campbell violated his duties, but he did so after a court already ruled against him once. Then Mark called me to the stand. I testified about the shed, the court ruling, and the continued fines. Then I told the court how Campbell ignored the law, threatened homeowners, and silenced dissent using fear and bureaucracy. The judge listened carefully. Then she looked at Campbell and asked a simple question: do you deny that these payments were made under your authorization? Campbell fumbled. I don't recall every transaction. That's not what I asked, she said. Do you deny approving these payments? Campbell went quiet. The judge then ruled on the spot. Based on the evidence presented, this court finds that Mr. Campbell acted in violation of his fiduciary responsibilities as HOA president. Further, the continued fines issued to Mr. Mason after a legal ruling constitute harassment. She ordered the following: immediate removal of Campbell from the HOA board. A full audit of the HOA's financials for the past 3 years, a court-appointed monitor to oversee HOA spending and elections for the next 24 months, restitution of $4,200 from Campbell personally to the HOA fund, $7,500 in damages to me for legal fees and emotional distress. The room erupted. Neighbors were whispering, shaking heads, some even clapping quietly. Campbell just sat there, stunned. That night, our neighborhood felt different. For the first time in years, people were smiling, talking freely. Kids played outside without parents, looking over their shoulders for a violation slip. We held a follow-up meeting and formed a new HOA reform committee with open elections, posted financials, and real transparency. For the first time, the community actually felt like one. And as for me, the shed still stands strong, simple, and untouched. A small structure that started a massive shift, and we weren't done yet, because what came next wasn't just accountability, it was a complete transformation. The day after the courtroom victory, I walked outside to grab my mail, and something unexpected happened. My neighbor, Mrs. Lindell, someone who had never spoken more than a polite wave to me, walked over, tears in her eyes, and handed me a plate of brownies. I just wanted to say thank you, she said, for standing up to him for all of us. It was a small gesture, but it hit me hard. I hadn't realized just how much fear Campbell had created in this neighborhood. For years, people had kept their heads down, afraid of being fined for the color of their curtains or the height of their grass. It wasn't just a homeowners association anymore, it was a dictatorship in disguise. But now, everything had changed. The court's decision had been swift and brutal for Campbell. Within 24 hours of the ruling, he was officially removed from the HOA board. His name was scrubbed from the association's website, the HOA's emergency contact number was reassigned, and according to my very amused neighbor who lived across from him, Campbell spent the following week locked inside his house, blinds drawn tight. He knew he was done. Legally, publicly, and socially. What most people didn't know yet was that he wasn't just forced to step down. He was personally on the hook for over $4,000 in misused funds and another $7,500 in damages to me, as ruled by the court. Money hit my account about 2 weeks later. I didn't celebrate. I didn't post about it online. I didn't gloat. Instead, I donated a portion of it to a local legal aid fund for homeowners being bullied by overreaching HOAs, and the rest? I used it to build a community garden right in my backyard open to all the neighbors. The same neighbors Campbell had tried to silence. That was the real win. With Campbell gone, the remaining board members finally came forward. A few of them apologized, saying they had felt pressured to follow his lead. Whether that was true or not, it didn't matter. We were starting from scratch. We held a neighborhood-wide vote, this time with ballots sent to every household, and elected an entirely new HOA board, this time made up of people who actually cared about the community, not control. One of the first things we did? Eliminated over 30 outdated or vague rules that gave too much discretionary power to the board. Implemented a public financial reporting system. Every dollar spent is now posted online monthly. Created a residents first policy requiring written notice and 2 warnings before any fines can be issued. And most importantly, we added a permanent exemption for basic repairs, just like the one that started my war with Campbell. Suddenly, things were peaceful, productive. People were planting gardens, repainting fences, hanging decorations, without fear of being cited or fined. Kids played basketball in their driveways again. Flags flew freely. Lawns weren't being measured by the inch anymore. The HOA became what it was always supposed to be, a community tool, not a weapon. I remember standing next to that shed a few weeks after the dust settled, just looking at it. It wasn't big. It wasn't fancy. It had a fresh coat of paint, a new roof, and a little lantern above the door I'd installed just for fun. But in a way, it had become a symbol of something much bigger. It was proof that one small stand against something unfair, against someone who had gotten too used to getting their way, could spark real change. Not just for me, but for dozens of families who had spent years feeling powerless in their own homes. That shed wasn't just a structure anymore. It was a statement. And people noticed. A few days after the garden was built, a local news reporter showed up at my door. Apparently, the clerk at the county court had tipped her off about the HOA case, and she wanted to run a feature on the shed that defeated a corrupt HOA. I agreed on one condition: she'd interview other neighbors too. The final story aired the following weekend, complete with footage of the shed, the community garden, and testimonies from at least 6 neighbors who had suffered under Campbell's rule. The reporter called it a rare example of one homeowner standing up and winning against HOA abuse. The video went semi-viral online. OA horror stories are everywhere, and it seems like everyone's either lived through one or knows someone who has. I started getting emails, messages, requests for advice. So I did something I never expected. I created a small online group for homeowners dealing with aggressive HOAs. We shared resources, legal advice, and real examples of successful resistance. Within a month, we had over 2,000 members. Within 2 months, 10,000. Turns out there are a lot of Campbells out there, but there are also a lot of people ready to fight back. They just need to know they're not alone. Sometimes I still laugh at how it all started with me just trying to fix a shed. No intention of making waves, no plans to go to court. I just wanted to stop the thing from collapsing, but that's life, isn't it? The biggest changes often come from the smallest cracks. Campbell wanted to make an example out of me, and he did. Just not the way he expected. He showed the neighborhood what unchecked power looks like. And I showed them what happens when you don't bow to it. Now, not only do I have peace of mind, a legal victory, and a better HOA, I have something more valuable. A united neighborhood that actually feels like a community. We're not perfect. Disagreements still happen. But now, they're handled with fairness, transparency, and respect. And that shed? Still standing strong, still legal, still mine.